everyone, and good day. Today is Thursday, June 8th. I've been on a 2-week holiday, 2.5 weeks, so I have to figure out my days and times, I guess. So Thursday, June 8th, 2023, and welcome to Will Work for Food, the New Possibilities Hour. It's a pleasure to be here, and as you know, we meet Thursday mornings at 8 a.m. Pacific time. There's no charge for these programs. We just ask that those attending make a donation in any amount that they're able to a food bank, either of their choice or of that suggested by the speaker. And today's speaker is from Toledo, Ohio, and his food bank is connecting kids to meals. He can tell us a little bit about that himself. But in the meantime, Natalie, do you want to tell us what the amount of donations of which we've been told, how much is that?
Oh, Jean, you know I do. Thanks very much. Our industries, the legal industry and the resolution industries, have told us about donations in the amount of $407,825.07. 3 years into our program and more than $400,000 in donation. It is greatly appreciated. Thank you all. I hope that when you're thinking about where you can donate money, you'll make a donation to your local food bank so that your friends, your neighbors, and your family can benefit from it.
Wow. Thank you, Natalie. That's just so amazing to think that we're coming up on $500,000. And I know we're, not quite 100,000 out, but closer to the $500,000 mark than we were to zero. And we wouldn't be there if you hadn't dreamt this up, Natalie. So congratulations. And thank you all. We wouldn't be there if everybody didn't donate. And so it's so appreciated. Thank you. Now, today's another fascinating topic, and it's on early dispute resolution. Our speaker is Peter Silverman, who is a litigation partner at Shumaker and has been an arbitrator and mediator since the late 1980s. He's a founder and chair of the Early Dispute Resolution Institute. And this is a whole new area. Even though we may talk about early dispute resolution, there's a formality to it that this institute has put into place. And so it's with great respect and pleasure that I introduce to you Peter Silverman. Peter, the floor is yours.
So the supporting organization is Connecting Meals to Kids, and they serve meals to children almost summer when kids are out of school, high poverty kids. And it's a wonderful organization. They serve 7,000 meals a day, and it's a lovely group.
So this is going to be about early dispute resolution. And my thesis is that the time has come to transform mediation, and that early dispute resolution in the form I'm going to talk about it is the way to transform it. So let's start by looking at how mediation's doing. And what we're going to do is look at it at a macro and a micro level. Macro is how is it doing in serving the public, and micro is on how it's doing in meeting the model standards as to what mediation should do. So in the late 80s, mediation started, and it became when the case is ready. That's the magic words. It goes to mediation. Since in the late 80s, the world has changed, right? So there's been changes in genetics, space travel, energy, computing, artificial intelligence, communication, vaccines, transportation, and music. But mediation, when the case is ready, is still the norm. And mediation does a pretty good job in resolving disputes, but let's look at how it's doing for the public. So we all know dockets are growing exponentially. Many cities or counties, it takes years to get a trial date. Most Americans and many small businesses can't even afford a lawsuit, so justice is out of reach. And those that can afford lawsuits are spending hundreds of millions of dollars on unproductive litigation before the case is ready for mediation. So it's not serving the public real well. Let's look at the micro level. So model standard 1 says that mediators shall conduct a mediation based on the principle of party self-determination. It defines that as the voluntary, uncoerced decision in which each party makes free and informed choices as to process and outcome. So let's see how mediation does in terms of model standard 1. I'm going to do a hypothetical exercise. This is a little tongue-in-cheek, but there's a lot of truth to what I'm going to say. So think about, how would you design a process if you want to maximize the opportunity to coerce settlement and to minimize the likelihood that parties are making informed choices? So first thing we might do is call it mediation, which is a real soothing name. Sometimes people get confused with arbitration, but that's good because they're a little confused. And we want to maximize pressure on the participants to settle. So let's not set this up until all the discovery is done, parties have spent a fortune, and trial is looming. We don't want to put any provisions in to make sure that the client can make informed settlement decisions. As far as we're concerned, the lawyers will just tell them what's a good or a bad settlement. We're going to require that parties submit confidential statements to us, because that way neither side will know what the other side is thinking. Only the mediator will know that. Counsel calls us and tells us they have a difficult client, we'll give them a call and we'll work on strategies on how to manipulate their clients. We'll tell them the mediation starts at 9, and it'll go as long as it takes, which could be until 1 or 2 in the morning, but we're going to stay in there. We'll start off by schmoozing everybody, listening empathically, and using all our tricks so that the parties learn to trust us. Then we're going to say the parties have to stay in the room all day as their frustration mounts and their willpower fades. Around 5 p.m., where we didn't make much progress, we'll start ramping up pressure. And then as we get into the evening hours, we'll use our closing techniques to bring resolution. Sound familiar? So that's one way to look at mediation, and it does not do a very good job in terms of self-determination, in terms of avoiding coercion and making parties have informed choices. So what we need to do is use the best in current thinking about trust building, communication, psychology, all the other things I've listed here: thinking biases, rationality, negotiation, probabilistic thinking, quantifying risk, forecasting in the face of uncertainty, to transform mediation. And so early dispute resolution under the early dispute resolution protocols does that. You can read the protocols at the website here. The EDR Institute is a nonprofit I formed. We have 3 trustees, Ann Jordan, Michael Hawash, and I. We actually present 2-day trainings on this. It's very dense material. It takes 2 days to train. We do it with the AAA, and we're going to have a couple more this year if anybody wants to sign up to get notified. So what
Mr.
is it?
Silverman?
Yeah.
I'm sorry to interrupt you, mea culpa. Before you get into the protocols,
Yeah.
we maybe look and see if you can enlarge your screen or even put it up where you've got the
Yeah.
slides next to you, because then these slides will be bigger. People are writing and asking if that can be done.
Let me you know, something's goofed up with my screen, and I realize these probably aren't working. And all I can do is I will send this slide deck to people, and I apologize.
Thank you. That's more than sufficient.
So, yeah.
Okay. Thank you. Well, then let's keep going.
Yeah, I will send this, and it's just a technical glitch. I had my technical person in here, and we just couldn't figure this out. All right, so what is the early dispute resolution process? It's a four-step process. It facilitates decision-making and resolution over 30 to 60 days. So you hear everybody say, oh, mediation's a process, not an event. It's baloney. If you schedule a one-day mediation, it's an event. It's not a process. So we provide for exchanging limited documents and information so people can be informed. Requires counsel to provide understandable information sufficient to make an informed judgment as to settlement, so clients are informed. And we use risk analysis tools to provide objective valuations that allow parties to engage in principled bargaining. Now I'm going to get into some core concepts. I'm actually going to only go two. If you look at the protocols, we have a number of core concepts, but I'm going to give you the two major ones. And when you get the slides, they actually refer to the protocols they're describing. One is we have something called an EDR neutral. An EDR neutral does four things. One, they design the process based on the protocols. It's flexible, so you don't need to say to parties, we're going to follow this to the letter. I never actually do it. So my practice is all early dispute now. I generally just do it informally. I just tell parties, look, we're going to start right away. We're going to share some information. We're going to use risk analysis tools. And then we're going to try and get to principled results, make sure the parties are on board with that. So the mediator, the neutral sets the process. They facilitate the sufficient information exchange, which we'll describe. They assist parties with calculating expected value of the case, which I'll describe. And then they facilitate principled negotiation, which I'll also describe. A key part of this is the ethical standards. So with the ethical standards, the key is this process works when you have good faith lawyers and clients on each side who want a principled result based on the true value of the case. If you don't, this process just doesn't work well. So you have to make sure parties are committed to that. And the standards and the protocols are lawyers have to fully explain this to the clients. So the clients understand they're voluntarily going to share information, even harmful information. They have to make a good faith commitment to seek speedy economical resolution on a principled basis. We require lawyers to provide the clients with the information they need to make informed decisions as to resolution. We require integrity, professionalism, civility. and lawyers have to balance advocacy with cooperation. We all do that in litigation anyways, right? Where we have to cooperate on discovery, motions, we're supposed to meet and confer while we're advocates. Here, it's a similar blend, but you're doing it without court rules. So people have to commit to this. I put this in my retention letter that the parties are willing to make this good faith commitment. First step is the case analysis. So to do this well, if you're going to do this early, right at the inception of a dispute, the parties need to take a real look at their case. It can't be one of these looks where you just say, okay, these are the basic issues, I'll get into this later. You've got to know your case because we're going to try and resolve it. We have to use Occam's razor. So in every mediation, we get to the point where somebody brings up 10 claims, 13 affirmative defenses, and finally we say to somebody, look, this is what the case is really about. And they say, yeah, that's right. This is what it's about. We have to do that right from the beginning because we're not going to be able to do the objective analysis unless we've simplified the case. We ask parties to say, we're going to ask parties to, lawyers to forecast the value of the case. So we say, what information do you need to forecast, to make an informed judgment as to the value of the case? This isn't discovery. It's just what are the key documents. And what I have found when I do this is it works remarkably well. I think all of us sense intuitively that in any case, if we could just say to the other side, look, here's what I really want to see. Do you have emails that talk about soliciting clients before you leave? If you do, produce them. And the other side might, have questions too. And so I say that to each party. What do you need? I generally have both counsel on the phone, and it works very well. Sometimes people want more and you kind of work with it because it's got to move quickly. You want this to happen in roughly 7 to 10 days. But it works remarkably well. And if sometimes the other side produces documents and they're not enough, you can ask for more. And then you determine if an expert is needed. I've only used an expert once in early dispute resolution for, it was a recall of refrigerators, and 20,000 of them had an ice maker that leaked, and the apartments got, or how homes got, carpeting got ruined, etc. And we had to have an expert test the part to see whether it was the supplier or the manufacturer. Apart from that, experts are always just battle the experts, right? We call our experts and say, look, on these facts, do you think this is negligent? They say yes, we hire them. They say no, we say thanks, I'll get back to you. So we find an expert who will say what we want, the other side does. It's a battle of the experts. They rarely add anything to valuation of a case. Next step is the exchange of documents. And there are protocols describing how you need to do this, but the reality is that both sides know exactly what the other side wants and should be able to produce it. As I said, I've never had a problem with parties getting the information they need. Under this procedure, you can question witnesses. So like in a fraud case, if I've got a great plaintiff, I might even say to the other side, look, do you want to spend 10 minutes and you can question the witness? I want you to see how credible that person is. Likewise, as a defendant, you might say, why don't you spend 10 minutes talking to my guy and you can determine how credible he is. So there's procedures for that. You can ask the neutral to ask the questions. Generally, it would be off the record, protected by mediation confidentiality. Finally, if there is concern about whether the other side's produced all the harmful documents, because you've got to produce the good and the bad. You can ask the other side to verify that they've made a good faith search and production. I have never had a party ask to do that. It's like discovery in court. You have no idea whether the party's producing everything. There's trust involved. Now we've got to steps 3 and 4, right? So we've narrowed the case. The lawyers have the documents they need for sufficient information. That's a technical term used. And then we go on to steps 3 and 4. This is where most of our training comes. It's in the objective case evaluation. So the first step is risk analysis. This does take some explaining. There's some technical terms, and then there's a lot of thought into what this really means. So I'm going to give you 4 thoughts, and then we'll get into the technical part of it. The first thought is forecasting confidence. So the question becomes, when do lawyers have sufficient confidence to forecast the value of a case? When is it optimal? And I'm going to ask you 3 questions, and everyone can take notes. On the questions, write down your answers, and then we'll talk about the answers. So, question 1. Let's assume a case comes in. So this is putting your lawyer hat on. You do a quick review of the key documents and the emails that your client sent you. Maybe you talk to somebody for a couple minutes about what the key parts of the case are. You say to the client, look, give me the bad news also, so I understand what I'm facing. And the client does. So question 1 is, how confident are you that you can predict the likely outcome of the case, which is almost always settlement, within plus or minus 20%? So don't overthink it. Just use your gut level as to how confident you are. When I say predict the outcome, it's, you'd say to your client, look, this case will probably settle around this number. So what's your confidence level? Second question. You now have a little more time. You've looked at the documents and you say to the client, look, there are a couple other things I really need to see here. You go back to some of the key people now that you've read the emails, talk to them for another 5 or 10 minutes, call up the other counsel, and she tells you her side of the case. How high is your confidence level in predicting the outcome of the case at this point? Just write down the number, anywhere from 0 to 100%. Question 3. You've now gone through discovery, depositions, everything. Emotions are all decided and trial is looming. How confident are you at this stage in predicting the outcome of the case, plus or minus 20%? All right. Now, what I'd like is if everyone could just raise your hand if your confidence level at stage 3 is your highest confidence level. Okay. Now, raise your hand if your confidence level at 3 is not your highest. Okay. So this was an intuition that I had, that I decided to test when I first started putting the protocols back together, because it's the key to this process. This survey's online. Well over 1,000 people have taken it now. But we first did it with 140 lawyers in an ABA session. And the average mean results were that lawyers felt after the initial information, the average was 57% confidence. after the second closer look, it jumped to 62. And then before trial it was 64. Now, there are many people who felt more confident before, after, all kinds. But the general range was pretty close to this. So the punchline is there's no benefit or the benefit's so small in going through discovery and depositions and motions in terms of predicting the outcome for your client, that there's no reason to spend this hundreds of thousands of dollars on discovery and depositions or whatever you're going to spend. And you can forecast the case at the beginning. People, if normal litigants, whether it's business or individuals, get information that says, look, I think the case is going to come out of this, and they take that information, they make decisions. That happens all the time. We all make decisions on imperfect information. And so if the lawyer can give the client a prediction and can give them reasons, the client then can make an informed decision. So that's a key thought in why this works. Second thought, gobbledygook isn't allowed. So what's gobbledygook? Lawyers say, yeah, we got a strong case. Well, it's an uphill battle. This is a tough case. Or I like our chances. One, lawyers don't know what they're saying on that. Are they saying it's 50%, 70%, 90%? And clients have no idea. My best guess is when clients hear we've got a strong case or I like our chances, clients hear, oh, I'm going to win this case. My best guess also is when clients hear, well, it's an uphill battle or this is a tough case, they probably think, well, my odds are better than 50%. I'm going to win, but the lawyer's covering his hind end. So gobbledygook doesn't help inform clients at all. And it lets attorneys off the hook. So we've got to require attorneys to make predictions in numbers. Third thought is the depth psychology. So in thinking about how people make rational, meaningful decisions, you've got to move people's thinking from fast to slow. Fast is emotional, quick, using rules of thumb. It's our immediate reaction to a case. Slow is deliberate, rules-based, rational. So you need time to allow people to move from this fast thinking to slow thinking. Second, you try and move people from soldier to scout. So soldier thinking is, this is a war, I have to defeat the other side. If I'm wrong on anything, that's a loss for me. So I'm going to stand strong, I'm not going to change my mind. Scout view is, all I need to do is give people an accurate picture of the map. And I'm going to try and do that. And so a process needs to get people into scout thinking by focusing on looking at all the variables. We've got to move people from you lose to I win, right? So when you first get a case, you want to crush the other side. This person, you've got righteous indignation and all that. You want to move people to the side of I win. I'm going to look just at what is beneficial for me. And if it's beneficial for me, I'm going to accept a resolution. Fourth thought, and here's where this gets a little dense. Probability is not intuitive. So we're going to require people, lawyers, to make predictions or forecasts. And lawyers make all kinds of probability errors in coming up with forecasts. I'm going to give you three hypotheticals, and given that the slides are small, I'll give you the assumptions. I'll speak them slowly, And what I'm going to want you to do is write your answers down. I'm going to ask your intuitive thought on probabilistic thinking. The first one deals with independent claims. So you've got a case where Susan runs a big business and she was fraudulently induced into entering into a contract. She enters into it, and then the other party breaches the contract, unrelated to the fraudulent inducement, so it's a double wrong. So she has a claim for fraudulent inducement. She has a claim for breach. Assume for me that she has a 50% chance of winning on each of those claims. What do you think are her overall chances of winning? Are they 75%, 25%, or 50%? So you can write down your answers. And the answer is 75%. And if we have time at the end, I can go through this for you, but basically what happens, I can give you a quick explanation now. We're doing good on time. Think of my 4 fingers as 25% each. So what happens, this is to help you think probabilistically, is Susan can win on her fraudulent inducement claim. So you take 2 fingers, 50%, you put them into the success bucket. But she might lose on her fraudulent inducement. So you've got these 2 claims hanging out there where she's lost on that. She can win half of those on breach. So you put another 25% in the success bucket, and you've got 75%. Typo 2, this is dependent claims. And again, we're trying to test how intuitive is probabilistic thinking when we're trying to forecast the results of a case. Here, Susan has just her breach of contract case, and there's a statute of limitations problem. So defendant says Susan is beyond the statute of limitations, and there's a 50% chance Susan will lose on that. Then defendant, and then there's the breach question. So there's a 50% chance of winning on that. What is your intuition as to Susan's chances of prevailing in the entire case? Why don't you write down what you think? 25%, 50%, or 75%? The answer is 25%. So again, I'll use my little 4 fingers. If Susan loses on the statute of limitations, you've got a 50% chance. So Susan gets 25%, 50% into the loss bucket. She gets past the statute of limitations half the time. So she's got these 50% remaining. She's going to win 50% of the time here. So you put 25% in the loss bucket. 75% chance of losing, 25% chance of winning. When you're thinking about cases, it's very hard, just even with these simple probabilistic thinking, to have good intuitions. Now, this is going to be hard to read, but I'm going to need you to write down these variables anyways, because I'm going to show you how we put them into a decision tree. So if you would write these down for me. Susan has a 50% likelihood of winning a trial in the breach of contract. So we're not going to worry about dependent claims, independent claims. Simple breach case, and Susan's manufacturing business says that supplies, you sent me lousy supplies, and the supplier says, no, you contaminated them somehow. Susan has 3 possible damage ranges based on 1 are actual, 2 is can she have consequential, and 3 is she's got an enterprise value claim. So you've got 3 levels of damages she can get. 1 is 100,000, the middle is 200,000, and the high is 500,000. Then Susan's law firm says it will take us $75,000 to try this case going forward. Okay, so these are the variables. And what's your intuition now as to the estimated monetary value of her claim? So if you have all these variables and you multiply them out and add them together, what's your gut intuition as to the value of this case? And I'll give you 30 seconds here because this does take some thought. All right, the estimated value, expected value is actually $58,333. Okay, now some of you may get that, some of you may not. I personally am not good at math, and so I struggle making any sense of these. But there is an easier way to come up with the numbers, and that's using decision trees. And all decision trees do is it's an app, and there's a free app on silverdecisions.pl that you can use. It's terrific. It's an app that forces you to think logically and that does the calculations for you. So if you've written down those 3 variables, I'm going to show you, I'm going to explain expected value, and then I'm going to show you what it looks like in a decision tree. Expected value is the average of the likely damage amount. So here it was 1, 2, and 5, discounted by the likelihood of their being awarded. So that would be a discount of 50% chance of winning and a 33% chance of each damage award. Then you also you've got fees that you have to put in there that they're going to lose no matter, Susan's going to lose no matter what. And in all these cases, we specify 3 factors: the percentage likelihood of winning, 50%, the percentage likelihood of low, middle, and high. In some cases, you might have 2, some cases you might have 4. Low, middle, and high tend to work in most of the cases I do this on. And then you have your future fees and costs through trial. Past costs are sunk costs. You just don't consider them. They have no rational basis. So when people say, I've got to get my money back, you can say that's not a rational way to think about the value of your case. So back to our hypothetical. And I'm just putting it up here. If you haven't written it down, 50% chance of winning at trial, damages 1, 2, or 500,000, 33% each, and fees are 75,000. This is a decision tree. Again, I'm sorry about the small, how it's going to come off small, but I'm going to explain this and you'll be able to see it when I send you slides. Decision trees, you have a grammar. So the yellow circle is what are called chance nodes. The green triangles are what are called terminal nodes. And the grammar is that the chance nodes are words and the terminal nodes are period. So every branch of a tree needs to start with a chance node and end in a terminal node. ignore all the numbers for now, which are going to be probably too small for many of you to read. You start a tree by starting with the chance node. Then, in this case, you can either win, you put up a win, or you can lose. If you lose, that's the end of the sentence, right? Susan loses, she's lost her 75,000 in attorney's fees. 50% chance of that happening. And you put those factors in. There's a window on the app that does this. And I'd be glad to show anybody if you want to email me how this works. And then if she wins, she's going to spend 75,000 on fees, but she's got 3 potential damages. So we need another chance node. And then we list the 3 potential damages: low, middle, and high, 33% chance of each. And the machine, the app, then does all the calculations and comes back and gives you the expected value of the case. What I do with parties is I ask them I try and set up a neutral model, right? If we've simplified the case through Occam's razor, this is a breach case, this is a misrepresentation case. And so you simplify it as much as possible, because these trees become impossible to understand if they're too complex. And I say, what do you think your chances of winning are? And what you're doing there is you're forcing people to move from fast to slow, right? Fast is, I want 500,000. Susan says, I want 500,000. That's what I'm going to get. That's my demand. The thing about, okay, well, there's 3 different possibilities and I've got a chance of losing. So all of a sudden, you ask Susan's lawyer to forecast what's the likelihood of winning here, what's the likelihood of these damages. And now, let's say both lawyers say, I've got an 80% chance of winning. Okay. And Susan says 80% chance of winning 500,000, 10% of the 2. What you've done is you're starting to move people to slow thinking. You're starting to move them towards scout mode. And you're starting to move them toward, what do I need to win? Because the expected value, you say, if I get better than the expected value, that's a good result for me. And the initial bracket then, instead of being 500,000 demand, is much lower, because you've done the percentages. And so let's say Susan gives you these, Susan's lawyer, very high predictions on likelihood of success. Maybe the number's now 380. And you can say, all right, why don't you start with that? And let's see if we can persuade the other side that this makes sense. You do the same for the defendant. The defendant's the other way. And you say, okay, on your analysis, instead of paying 0, this shows that with your basic assumptions, accepting everything, that if you can pay less than 130,000, this is a win for you. And so all of a sudden, you've narrowed the brackets, and negotiation can proceed from there. We spend half of our time in the training on decision trees. I talked about dependent and independent claims. You've got to figure out how to put in counterclaims, contingency cases, American rule fees, and shifting fees. And it's complex, but once you learn it and have the basics down, this becomes just like any other skill. You then have to put in subjective risk factors. You talk to people about leverage, risk tolerance, business impact, collectability, and you say what you want to do is take those factors with your expected value and come up with internally what you think a reasonable settlement range is for you. So if Susan's expected value is 380 based on her high assumptions, and the risk just doesn't bother her, she's got a big business, she might say, look, I'm going to need 300 to settle. If the defendant has a possibility of going out of business with a $500,000 judgment, even though their expected value is 100, they might say, I can't afford to take this risk. And so maybe 200 is it. That's their internal value. You ask the lawyers to give their clients discuss their clients a reasonable settlement range based on all these facts. And then you say, I don't want to know your bottom line, which we do as mediators. You can tell me what you think, and I'll understand it's your negotiating number. You don't need to tell people this, they generally figure it out, but they are talking then about facts you can talk about. Percentage likelihood, well, we considered this. What if this happened? Why are you saying 80%? What if it were 70%? You can show them the numbers. And so there's all kinds of things you can work with parties on. When you get to final resolution, which is step 4, we engage in what is called principal negotiation, facilitated by the EDR neutral. Now, everything you've done should take maybe a couple weeks if the parties are working with you. So you're doing this all by conference call with lawyers and parties. And then you've got your initial numbers, what the plaintiff is demanding, which is going to be much lower, and what the defendant is offering, which will be higher because they're using probabilistic thinking rather than positional. So then as a neutral, you can begin to bring offers back and forth and use the techniques I talked about, which is really talking to people about the objective merits. You want to say to them, look, you want to find something that's good for you. And you move them from this, I want to crush the other side, to what's good for me. And then the counters go back and forth based on all the objective factors you have on the table, which makes for very positive types of negotiations and not the positional nonsense that we all deal with. You may come and you take offers back and forth, and there's still a ways away, and you'll say, look, if we don't get this resolved, we are going to have a final mediation, and but it's only going to be half a day, right? We've covered all this ground. This is just to finish it off. And this avoids all those problems I talked about earlier, where mediation can be manipulative and coercive. Parties have had a lot of time to think about this. The clients are informed. You're not putting people in a pressure cooker environment. And you could then have a half-day mediation to resolve it. We're now bringing these trainings all over the country. We've trained over 100 neutrals and advocates and judges. We've presented to the United Court System in New York. And we are going to do 2 more trainings. And with AAA, we plan to do trainings all around the country. There are 2 pilot programs that have started. One is in Harris County, Texas, and it's been going for a couple years now and is very successful. And I could send you information on that and forms if anybody wanted. Another is Southern District of Michigan, an Eastern District of Michigan judge attended our last session, Judge Murphy, and he started a pilot project in the Southern District, Eastern District Southern Division. I can send you his referral orders. And in the next ABA Just Resolutions newsletter, Dennis Barnes, who's one of the EDR facilitators for that program, is writing an article about how well that's going. We're presenting to many other court systems now. September, I'm going to present to the Northern District of Ohio. We're presenting to courts in New York, where I told you we presented the unified system. And so it's very exciting. I also plan to be teaching the first law school course on this next year. And we give a number of lectures at law schools. So that's a brief overview of what we usually do in 2 weeks of training. And I wanted to leave a little time if people have questions. And if they don't have questions, I've got a couple other things I can talk about, but see if people have questions.
Thank you so much. This is fascinating. What is the link, or where can people go to see the tool? You mentioned a website, or
So if you want to see the protocols, you go to the Early Dispute Resolution Institute website. If you want to use a free app to start fooling around with decision trees, the one I like to use is silverdecisions.pl. Let me just check that quickly. I think that's the URL. It's an open source site, and the PL, silverdecisions.pl is Poland. So it was a group of Polish mathematicians, basically, who created an open source site, and it works terrific. And as I said, if anybody's interested, you can just send me an email and I'll walk you through it so you can start using it and fooling around with it.
thank you. Have you tried any of the new AI?
So,
aspects of this?
so we have the new AI, I mean, in probably now that it can do these calculations. What AI can't do is assumptions.
Sure.
Lawyers have to make the calculations. The first AIs did not do these calculations correctly, but I'm sure that's probably been fixed by now.
You know, there are more and more of these kinds of tools coming out for mediators and counsel to use. Are you aware of Peacemaker?
No.
Peacemaker.legal. You
No.
should look at it, and everybody who's listening to this should. It's fascinating. It's just, well, it's been in the works since 2019, but it's now online, and a judge out of Georgia, I believe he is, has put it together. Very similar, making these various assumptions, your numbers, your, you know, if there's going to be a substantive ruling or not, things like that. So anyway, does anybody have any questions for Mr. Silverman?
We've got to be skeptics out there, practical tips.
I have a question.
Yeah.
In your example, you started with each argument, each cause of action or argument had a 1/3 chance of success.
Right.
Where'd you get the 1/3 chance of success?
Pure, just for simplicity in the hypo. In real life, what you'll do as a neutral is you'll go to the plaintiff and say, give me your percentages. You'll go to the defendant and say, give me your percentages. So, or you can create a neutral tree like that and say, here's what it looks at 50%. How would you like to change it?
Mm-hmm. Okay.
This was
Yeah,
just
because a lot of times there's a huge
every time
disagreement every time.
the
You know,
plaintiff, they've got an
yeah.
80% chance of winning, defendant. And so you put that in the tree. The magic of that is that it narrows people. And then you can say, well, how confident are you it's 80 rather than 70? You can show a client what it looks like is 70. Normal people in business, I mean, business people use this in everything. They're very sophisticated at this.
Right, right. Although I will make an argument that, you know, oftentimes, at least in the disputes I've been involved in, money is a big part of it, but it's not the only part of it.
Correct.
And when you're looking at the cost of litigating versus you're cutting your losses consist of a lot more than just the
Yeah.
legal fees involved.
Yeah, so this can be used in any kind of case.
Right.
And so if they're interest-based, I mean, you use your interest-based thinking. This just is the quantifying the money.
Right, understood. Thank you.
I know certainly defense firms in civil litigation, probably most of them teach their associates this from the very beginning, because for early dispute resolution, that's the goal. Just get in, try and get the case settled. So this is
Oh,
fascinating. Thank you.
So I've been wearing this 15 years. The AAA adopted the training 2 years ago, and it's now being accepted, but lawyers had huge pushback, right? This will cut fees tremendously. It's now becoming very widely accepted. And as people work through the protocols, they understand, okay, this is very doable. It's, you know, we have shared understanding, mutual trust. And as neutrals, for those who you are, the easy way to start is when somebody calls you, you just say, and they say, do you have time in August for mediation? Say, I do, but what I'd like to do is start tomorrow. We'll share some information. We'll try and value the case objectively and see if we can resolve it before mediation. And once you start doing that, lawyers love this, clients love this, and people start calling you again because they want you to do this. A lot of people say they do this. It's very complicated to learn to do it right. Once you've learned it, it's very easy. But a lot of people who are doing it just, you know, they're just kind of feeling their way, and it just doesn't work that well.
Hmm. Well, it's the top of the hour, wherever we are in the world, it's the top of your hour. So thank you all so much for being here today. Thank you, Mr. Silverman, for a fascinating presentation. And if anybody wants the slides, you can email Mr. Silverman. I'm sure he had said that already that he'd be happy to share it. And thank you again. Just really appreciate it.
Okay. Yeah.
Okay. We'll
Thank
see
you
you
very
next
much.
week.